Hi, I'm J.D. Piro, Senior Vice President at Aon Hewitt, and this presentation, which I'm doing for the U.S. Chamber of Commerce, is about the different laws that regulate wellness programs. Wellness programs have the dubious distinction of being regulated by not one, not two, but three different federal laws administered by four separate federal agencies. And only one of those laws, which is HIPAA, actually has a comprehensive regulatory scheme that's out there for employers to follow. If you take a look at the first slide, you'll notice that wellness programs are broadly defined and divided into two categories: participatory wellness programs and health contingent wellness programs. And to make things even more complicated, health contingent wellness programs are divided into activity-only programs and outcomes-based programs. And if you want to get into a little more detail, the outcomes-based programs allow you to give rewards, but those rewards have to be limited. They can't be more than 30% of the cost of the coverage that's been elected by the employee. That can go up to 50% in the case of tobacco cessation programs. For the two other laws, the Genetic Information Non-Discrimination Act and the Americans with Disabilities Act, there are no regulations out there. Under GINA, employers are permitted to collect family medical history from employees. But family is very broadly defined. It includes not just the employee, but includes the employee's spouse as well. So that makes it a little more complicated when you're trying to collect information on the health status of employees and their spouses, because GINA doesn't permit that to happen unless it's in accordance with the statute. In addition, the Americans with Disabilities Act allows wellness programs the same way as GINA does, only they also have to be voluntary. And voluntary is a term that really hasn't been defined, at least until now. In 2014, as you'll see from the next slide, the Equal Employment Opportunity Commission sued three employers for wellness programs that they considered to be too aggressive under GINA and the ADA. You could even argue that some of them were aggressive, but there's an argument for all of them that they were permissible under HIPAA. And that's what employers have been doing for the last few years. They've been designing programs under HIPAA and expecting them to be compliant under HIPAA, and then figuring that it would be okay under GINA and the ADA. At least according to the EEOC, it hasn't really worked out that way. The EEOC, as you'll read from this slide here, said that the programs offered by these three companies were far too aggressive. In one case, the employers ended up forfeiting the employees' health care contributions and required them to pay the entire cost of coverage if they didn't fill out a health risk questionnaire. In the case of Honeywell Industries didn't have a program like that. What they did have was a fairly aggressive set of financial penalties if you did not participate in the wellness program. But again, all three of those programs were arguably legal under HIPAA. Now, the EEOC wasn't successful in trying to stop the implementation of those programs, but they did put out proposed regulations under both of those statutes. As you'll see from the next slide, the Americans with Disabilities Act has proposed regulations out there which actually are a little bit more restrictive than what's required under HIPAA. In those situations, the Americans with Disabilities Act permits employee benefit wellness programs, but they have to be voluntary. And voluntary means that you can't limit an employee's choice of benefits under the wellness program. That means for a lot of employers out there who have two-tiered benefit plans, one if you sign an HRQ and fill it out, the other if you don't fill out an HRQ. In those cases, HIPAA would permit those types of programs, but the ADA would be a little more suspect. In addition, there are two other provisions of the Americans with Disabilities Act that are different than under HIPAA. In the Americans with Disabilities Act, there is a much more restrictive limitation on the financial reward that's provided to the employees, as you'll see from that slide there. In addition, there are also significant restrictions on smoking cessation programs. One set of limits on rewards apply if you're asking about smoking status. A second set of limits apply if you're actually testing for tobacco use. As you see here now on slide 4, the EEOC has proposed regulations under GINA, which provide a third way of calculating the financial rewards. In this case, the reward is limited to 30% of the cost of the coverage in which the employee is enrolled, along with the employee's spouse, but there's an apportionment of the reward. A certain portion is attributable to the employee's participation. The rest of it is attributable to the spouse's participation. So in this case, you actually have three possible regulations, one final, two proposed, that have three different methods of calculating the financial incentives available to an employee in wellness programs. And as a result, three different calculations that employers have to go through in order to be sure that they're compliant with the law. It all goes to the question of what's a voluntary wellness program. And as we've noted here, the EEOC has a very different definition of voluntary than the other three agencies that are administering wellness program rules. And that's where the courts come in. As you can see on this page, a court in the Western District of Wisconsin ruled that it doesn't matter under the Americans with Disabilities Act whether the program is voluntary. What simply matters is whether or not the program is part of a safe harbor under the statute. If it's a program for administering, managing, or classifying risk, then it's permissible, and you don't even have to look at whether or not it's voluntary. Not surprisingly, the EEOC disagrees with this interpretation, and they'll likely be filing an appeal for this. So, if you want to find out what happens with that, tune in for the next chapter. More to follow.